Swayam Prabha. Digital India. Educated India.
A of IPC is to be taken as Section 85 and 86 of BNS, and Section 494 of IPC is to be taken as Section 82 of BNS.
Hello all, this is Professor Shivani Goswami and I am teaching in IP University. In these presentations, today's presentation is lecture 3. I have already dealt with 2 lectures. Today I would be talking on judicial separation and divorce. In my previous 2 lectures, I had already talked about, I talked about that laws could be territorial or personal. Territorial laws are applied throughout territory of India and they are uniform in the sense it could be Indian Penal Code, it could be Indian Contract Act, which is uniformly applicable to all the parties, whether they are Hindus, whether they are Muslims, whether they are Christians. So we do not have any act like Muslim Contract Act or Muslim Penal Code. It's Indian Penal Code, irrespective of the religion of the parties. If you are an Indian, and Indian law would be applicable to you. On the contrary, conversely, if we talk about the personal laws, they are applicable to the people who belong to a particular faith, religion, culture. For example, Hindu law is applicable to Christians, so on and so forth. I talked about in my 2 slides that we were talking about the Hindu Marriage Act, and I talked about the jurisdiction. I stated that it is applicable throughout India except for the state of Jammu and Kashmir, and it is also applicable to people, of course, who are residing within the territory of India, and also to the people who are outside India. But if they have a domicile in India, then also the Hindu Marriage Act 1955 is applicable on them. It came into operation on 18th May 1955, and it talks, when I say that Hindu, as such, the word Hindu is not defined under any of the acts, but it specifically says that who are the persons on whom Hindu law is applicable. So it could be Hindu by birth, it could be Hindu by religion, it could be a person who is not a Muslim, Christian, Parsi or Jew and who have been Hinduized. Then we also talked about Section 3, Section 4. Section 3, it's basically the definition clause. We had looked into certain definitions, like I talked about Sapenda relationship, I talked about degrees of prohibited relationship, I talked about half-blood, full-blood, uterine brother and sisters, brothers or sisters, and we talked about a district court, so on and so forth. Section 4 again is one which says that if any of the provision is inapplicable in the sense that it is inconsistent with the provisions of the Hindu Marriage Act, then they are not applicable. So now it's the Hindu provisions of a Hindu Marriage Act which is applicable until and unless, specifically and explicitly it is mentioned under the Act that these things are, custom is approving the same. So that's a different story. But otherwise, whatever are the provisions of the Hindu Marriage Act now, from 18th May 1955, they are in force and they are applicable to the Hindus in India. Then apart from this, we had also talked about Section 5. Section 5 is again a very important section which deals with the essentials of valid marriage. And I talked about monogamy, we talked about mental disorder, we talked about the criteria of age, Sapenda and prohibited relationship. Also, Section 9 and 7 we also dealt with. Section 7 is dealing with the ceremonies, and Satpadi is an essential ceremony which needs to be complied with if it is there. So that means 7 steps around the fire is a mandatory requirement and it has to be there. Then apart from this, Section 9 was again a very important section, restitution of conjugal rights. So if either of the spouse, that means a married couple, only has this remedy, and if they withdraw from the society without any reasonable cause, without the consent of the petitioner, then the aggrieved person can move to the court and apply for restitution of conjugal rights. Now this is very important because after marriage, you need to have the society of your spouse, you need to have the consortium of your spouse. So if anyone one of this without any reasonable cause and without the consent of the petitioner moves away, the other aggrieved party can move to the court and apply for the same. Void and voidable marriages are dealt under section 11 and section 12. Void marriage is no marriage at all and you need not even go to the court. But on the contrary, conversely, if you talk about the voidable marriage which is dealt under section 12 of the Hindu Marriage Act, there are 4 grounds: impotency, mental disorder, consent obtained by fraud or force, or concealment of pre-marriage pregnancy. So we had discussed in length all these things in our previous lectures. Today's lecture is basically on judicial separation and divorce, that is section 10 and section 13 of the Hindu Marriage Act 1955. Again, a very, very important section, because when you talk about, people do get confused as to what they just feel that judicial separation is similar to divorce. Because when you're talking, people do feel that when you talk about judicial separation, that means judicially you are separated. So it's a case of divorce only. So a person who is a layman, if you tell this word to him, he will say they are one and the same thing. But that is wrong. Judicial separation and divorce are 2 entirely different concepts. One is dealt under section 10 of the Hindu Marriage Act, that is judicial separation, and second, divorce, is dealt under section 13 of the Hindu Marriage Act. Now, when you talk about this judicial separation, it basically, it's a, of course, there is a formal decree. It's a, you'd say it's a decree of separation, and it is done by the court only, provided the party moves for it. And of course, the grounds for judicial separation and divorce under section 13 are same, but judicial separation is considered to be a lesser evil as compared to divorce. Why I am saying so is, I have my reasons behind it, because in the case of judicial separation, that is just that your marital ties, your conjugal relations are temporarily suspended. It is not the dissolution of marriage. You still have chances to reconcile, you still have chances to be together, which is not the case under your, if divorce has taken place, under section 13 of the Hindu Marriage Act. So that is the reason why we say that judicial separation is a lesser evil as compared to divorce, which of course puts your marriage to an end. Divorce puts marriage to an end, and after that there is no relationship between these people and they are free to go the way they like. Wherever they go, they are free to remarry. They can go their own way. So they are as good as free birds after divorce. Now, when in the case, of course, whenever we see our courts, the courts are always under this thing, because we have seen when we talk about children, the welfare of the children is paramount. And it is always felt that whenever there is a dispute between the couple, that is a husband and wife, the most affected party are the children of that couple. So, if at all any, if the parties are at daggers drawn with each other, they keep on fighting. Children are witness to all these evidences, and when you see a particular thing in front of you, which is happening day and night, it has a very bad impact, children carry a very bad memory as far as those incidents are concerned. So, in the case, and of course when divorce takes place, it has a bad impact, though nowadays people do say, if you go to the courts, a lot of litigation is there and people are taking divorce because they feel that they are incompatible with each other. They have several grounds which are mentioned under the Hindu Marriage Act, and they go for these grounds and they're taking divorce. And then divorce by mutual consent is the simplest way to take divorce. But it is always said that when the parties are separating, when you have a turbulent marriage relationship, conjugal relationship, marital relationship, the most affected party, apart from the couple, of course, when they are going through all this bad phase, it has bad memories only, but the most affected are the children of this couple, because it carries with them very bad memories and it is ingrained, it is imbibed in them forever, those bad memories which they do not want to even look them afterwards. Then, so that means the welfare of the children being a paramount this thing. So, judicial separation is considered to be a lesser evil, and here chances are given to the parties, because sometimes It might happen that out of certain, you just get angry at the spur of the moment, but later on you realize that no, it was not good. And in the case of judicial separation, a time period is given to you to rethink, to reponder that what was it, and you have chances of reconciliation. So that one period time is given to you so that you can reconcile, you can be together, you can enjoy your conjugal and marital relationship. That is the reason why we say that it is lesser evil as compared to divorce, and they are entirely two different concepts. As I have stated, one is dealt under section 10 and another one is dealt under section 13 of the Hindu Marriage Act. Then as far as the section 10 is concerned, it could be either party. That means even for that matter in section 13 also, the remedy is available to both persons. That is, husband can also move or wife can also move and claim this remedy of judicial separation. Then when we talk about judicial separation, earlier, it used to have 6 grounds within it, and in 1964, it was felt that it should be modified, it should be elucidated, and some modifications are required under it, as a result of which, under Marriage Laws Amendment Act 1976, it was aligned with, the judicial separation was aligned with divorce, and it was also available to the parties even if before the act came into operation. That means it has it's retrospectively available to the parties. So even those marriages which have taken place before 18th May 1955, this remedy of judicial separation is also applicable on them. Like I stated in my previous lectures, I talked that in the case of void marriage, it's a prospective thing. So the marriages which had taken place before 18th May 1955, void marriage, this section 11 is not applicable on them. Conversely, section 12, voidable marriage, that is operative retrospectively also, so that even those marriages which had taken place before 18th May 1955, it is also applicable on them. Similarly, in this section 10, this is also applicable to the marriages that have taken place before 18th May 1955, so it has retrospective operation also. Then, although the grounds for judicial separation and divorce are same, but they are two distinct things, as I have already stated. It's a lesser evil and divorce is a bigger evil. Now, I'll just read this section and then I'll explain it to you. Section 10 of the Hindu Marriage Act, it says that either party to a marriage, whether solemnized before or after the commencement of this act, I've already told you that section 10 is even before solemnization, that is before 18th May also this is applicable. So it states that either party to a marriage, whether solemnized before or after the commencement of this act, may present a petition praying for a decree of judicial separation on any of the grounds specified in subsection 1 of section 13, and in the case of a wife, also on any of the grounds specified in subsection 2 thereof as grounds on which petition for divorce might have been presented. Subclause 2, it says that when a decree of judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit with the respondent, but the court may, on the application by petition of either party and on being satisfied of the truth of the statement made in such petition, resign the decree if it considers it just and reasonable to do so. So from the wordings of this section, it is clear that this section is applicable to both the parties, that is either the husband or the wife, number one. So any one of them can move to the court and apply for this legal succor which is available to the party and is considered to be a lesser evil as compared to divorce. And secondly, it is also applicable to the people who got married before 18th May 1955. So it has a retrospective operation also. And it states that the grounds for judicial separation and divorce are same, because it is stating that whatever is mentioned under subsection 1 of section 13, and also the additional grounds which is available to the wife, because all of us know that there used to be 9 grounds for divorce available to both the spouses, that is the husband and wife. Now one has been deleted because leprosy is no more a ground, so now we consider it as 8 grounds, and 4 additional grounds are available only to the wife and not to the husband. So these are the grounds that are also available under judicial separation. 8 grounds plus those 4 which is available only to the wife and not to the husband. Now these 8 grounds are available to both the husband as well as the wife, but those 4 additional grounds are available only to the wife and they are not available to the husband. Specifically it talks about this thing. When we talk about ingredients of decree of judicial separation, number 1 is marriage remains intact. That means there is no dissolution of marriage, number 1. Number 2 is the marital ties are just temporarily suspended. Temporarily suspended means it doesn't come to an end. It continues. So you are still a married couple even though you have obtained a decree of judicial separation. Then apart from this, after the decree of judicial separation has been obtained, the parties are under no obligation, it's not mandatory for them to live under one roof. They can live under one roof. Of course, they will not be living like husband and wife. They can live under one roof, but they can also separate and they can also live under separate. So they are not under an obligation to live together as husband and wife. Then another thing is, under judicial separation, there are still chances of reconciliation. As I have stated, a time period of 1 year is given to the couple to rethink, to reponder. I have already stated this thing, that to whatever decisions they have made, whether they can move together or now they are in such a situation that they cannot move together and they have to live separately forever. So that time period is given to rethink whether you are in a compatible position, you can live together or you cannot live together. So in a way, they do have enough time to think over whether they are taking this decision in a haste or whether they need to rethink and whether they want to be with their partner, with their spouse. So all this time period is given. So that means this time period is very important, and it is through this time period only they make their decision whether they want to live or they do not want to live together. As I stated, that marital ties are just suspended. So that means if you go for another marriage during the time when a decree of judicial separation has been given to you, then you can be prosecuted for bigamy by your spouse, because the marriage has not come to an end. It is not dissolution of marriage. It is just a suspension. Just a time period is given to you, although you are under no obligation to live together, although you do not have any mutual rights and obligations towards together during this period of time. You can live separately, you can, but the thing is, if you go for, but you are not a separated couple, in a sense that you can say that it's separation from bed and board, but it is not the dissolution of marriage. It is just the suspension. So there is a difference as to suspension and dissolution of marriage. If any one of the spouse during this period of time, the time when you have already obtained a decree of judicial separation, go for another marriage, he or she goes for it, then the other aggrieved person can move to the court and prosecute you for bigamy under section 494 of the Indian Penal Code, and the punishment is 7 years and fine. 7 years imprisonment and fine. So this is a time period you should not act in a hastily manner and could move forward, because this is not the time period when you can move forward. So it's after divorce that you can move forward and you can go for another marriage, but judicial separation during this period, you are in any case not allowed in any of the circumstances to go and solemnize another marriage. If you do it, you are putting yourself in a risk. So the spouse can go and prosecute you for bigamy under section 494 of the Indian Penal Code. During this period, because the marital ties are suspended, So either of the spouse can ask for maintenance. Maintenance, we know that when we talk about maintenance, Hindu Adoption and Maintenance Act is also there, Hindu Marriage Act is there, then you have CRPC, your section 125 to 128, it talks about maintenance provisions. But remember one thing, that it is only under the Hindu Marriage Act that any of the spouses can ask for maintenance from the other spouses. If it's a case of Hindu Adoption and Maintenance Act, the privilege is given to the wife. So that means husband is not allowed to ask for maintenance under Hindu Adoption and Maintenance Act. If you take CRPC, that is Code of Criminal Procedure, section 125 to 128, again the privileged party who can ask maintenance is the wife and not the husband. So that means it is only the Hindu Marriage Act 1955 where either of the spouse can ask for maintenance. Section 24, 25 of the Hindu Marriage Act, 24 talks about the interim maintenance, that is maintenance pendent light, when the proceedings are going on, and if you are unable to cope up with the case and so on and so forth, then you can ask for maintenance during that time period. And permanent maintenance is that's a maintenance when you are unable to live, unable to sustain yourself, you are not earning, you are not able to meet your daily requirements, then you can ask for maintenance from your spouse. So what I'm trying to say here is that it is only the Hindu Marriage Act where husband has also got the right to ask for maintenance from the wife. In no other acts, be it Hindu Adoption and Maintenance Act 1956, be it your CRPC 1973, in none of these acts it's the husband, it is only the wife who can ask for maintenance from the husband. Because it is always felt, although now things are changing, the scenario is changing and women are also working, they are equally working. I stated that even in some of the cases they are more educated, they are more earning than their spouse, but earlier the scenario was not the same. And it was usually, there's always a belief that the man of the house is going to go outside and he is going to earn the livelihood, and the women of the house, she is going to do the household work. But now things are changing, scenario has changed, now we have working women, so that was the reason why it was always felt that maintenance could only be claimed by the wife and not the husband. But Hindu Marriage Act gives this special remedy, and even the husband, if he is not that well off, he is not able to sustain himself, he is not able to maintain, and maintenance is just the basic necessities. It is not the luxurious life. So you cannot ask for, when you are asking for maintenance, you cannot ask for any kind of luxury. It is just the basic necessities that are required. It is just the lifestyle that you were living during the time when you were a married couple that you could be getting maintenance as to that much amount. So any of the spouses during that time of judicial separation can ask for maintenance from each other. Mutual rights and obligations are they are just suspended. So that means you do not have any mutual rights and obligations during this period of judicial separation. And let me tell you here one thing, we will be talking about Hindu Adoption and Maintenance Act in my later classes, but one thing is that we need to know is, we know as to what is adoption of a child, because we adopt a child. So it's till 15 years of age that a child can be adopted, and until and unless the custom approves otherwise. So there are some places where even married couples are adopted, but the act says that 15 years is the age till the child, you can adopt that child. Now here, if during the time of judicial separation, adoption in a layman's language is, I can say that it's an uprooting of a child. When you take away the child from the natural family and he is given in the family, adoptive family, right? So all his ties in the natural family are broken and he becomes a member of the adoptive family. So all rights occur therein. Barring one thing only, that he cannot now after adoption marry any of the female relation which he couldn't have married had he been in the natural family. So that's the only tie that remains. Otherwise, when a child is being adopted, all his rights and obligations in his natural family comes to an end and he totally becomes a part of that adoptive family, and all mutual rights and obligations are occur, and he is and he has to be treated at par with the natural born child with an auras putra or putri, and he has to be, there cannot be any demarcation, there cannot be any bigotry, there cannot be any disparity between a natural born child and an adopted child. So when you are in a period of judicial separation, when we study adoption, one of the requirements is that when a male has to adopt a child, a male could be a bachelor, he could be a divorcee, he could be a widower, and he could be a married man. So these are various categories of a man, right? In all the three cases where he is single, that is when he is a divorcee, when he is a widower, or when he is a bachelor. In all these cases, he has the capacity to adopt a child and he doesn't require the consent of anyone. In the case of married one, the restriction is whenever a married male has to adopt a child, he needs to take the consent of his wife, and that consent is mandatory. Now here, if when you are during the time of judicial separation, if at all you want to adopt a child, whether a son or a daughter, of course if you have a son, you cannot adopt a son. If you have a son or a son's son, there are certain things which are mentioned under Hindu Adoption and Maintenance Act, which I will be talking on later on. You cannot adopt a son, you can adopt a daughter. Similarly, if you have a daughter, you cannot adopt a daughter, you can adopt a son. So here I am just taking an example. Let's take an example here. If the husband wants to adopt a son, here, because the marital tie is suspended, he needs to take the consent of his wife, because that woman through whom you are judicially separated, she is still your wife. So you cannot in a way adopt a child thinking that you are judicially separated and you are as good as a single person and you can adopt in your own capacity. It is not like that, because that woman is still your wife, and if at all you have to take a child in adoption, whether a son or a daughter as the case may be, you need to take the consent of that woman, although you are judicially separated, because it is just the suspension, it is not the end of your marital ties. Had it been the case of divorce, if you would have been divorced, because that's a dissolution of marriage, in that case, after divorce, you need not take the consent of this woman, because now she is no more your wife. You can adopt, you are as good as a single person, like I stated, that a divorcee can also in his own capacity adopt a child. So this person now can adopt a child without taking the consent of anyone in his own capacity, and he is not required to take any consent. But the same is not true with regard to judicial separation. Why? Because marital ties are suspended. It has not dissolved. It has not come to an end. So you need to take the consent of that woman. And if you do not take that consent, that adoption is not valid. It is void. So that would not be considered as a valid adoption. Similarly, if you are during this period of judicial separation, you are in a period of judicial separation, and God forbid if accident takes place and any of the parties die, either the husband or the wife, so you have inheritance rights, you have property rights, because it is still the case of that the marriage was not dissolved. You are not a divorcee. The marriage has not come to an end. In this period of judicial separation, your inheritance rights are also intact, and if any party die, so the other one has got a right in the property of this person, because you were still the wife, although it was a suspension period, but the marriage had not dissolved. The same is not true had divorce had taken place, because during that time you are no more husband and wife, and if at all any one of the party died after divorce, your ex would not have any right in that property, because now she is no more a part of that family and all her rights has come to an end after divorce. Now, when we talk about this, as I have already stated, that judicial separation is a lesser evil as compared to divorce. The grounds for both of them are same. There are 8 grounds which are available to both the husband and wife, and 4 additional grounds are available only to the wife and not to the husband. Remember one thing, that in the cases of judicial separation, it is not applicable to void marriage. So that means if it's a case of a void marriage under section 11, the parties cannot apply for judicial separation. So that it is not allowed. And I've already stated that Marriage Laws Amendment Act had aligned. Earlier there were only 6 grounds, but due to the alignment and in Marriage Laws Amendment Act 1976, it has been aligned to divorce, and now they are, whatever the grounds are there under divorce under section 13 of the Hindu Marriage Act, identical grounds are there under judicial separation. Now the question comes, when the grounds are available, the grounds are identical, the grounds are similar, why would the party go for judicial separation? They would obviously go for divorce. Because people, when you are thinking of moving to the court, it is not in the normal wear and tear of married life. When you are thinking of moving to the court, that means something is fishy, something is fishy in the sense, now things have gone beyond repair, and that is the reason why you are taking the help of the court. And it has been stated also by so many people, scholars, that when you are making the grounds for both these judicial separation and divorce as identical, why would the party go for judicial separation? They would obviously take the recourse of divorce, because it is not a requirement that if at all you have to apply to the court, you have to first get judicial separation and then you can go for divorce. It's not. It is your choice whether you want judicial separation or you want divorce. So that's the choice of the party where they want to move in. So the question is, and it has so many times it has been put, that why judicial separation? When divorce is available, the grounds are similar, they are exactly identical, there is no difference between any of the grounds. Why would the party come under judicial separation? We know that we are living in a very traditional society, in a very conservative society, in a very gullible society. And in India, it matters a lot, even today, when we are bragging of everything, bragging of equality, we are conceding of egalitarianism, and we are conceding that there is no difference between man and women, and now we are going towards westernization. Still, we have a society where a divorcee is not being looked with good eyes. In the sense, there is still a stigma that is being attached. People do say that, oh, she is a divorcee, he is a divorcee, right? So that he or she, they were not compatible. Although now it is very common. I might be sounding somewhat awkward that why I am saying so thing, but India is not Delhi. When you go to India as a whole, there are a lot of villages. India lives in villages. So people outside Delhi, because Delhi is not India. In Delhi, we do say that it's a cosmopolitan thing, people are advanced, and it hardly matters. And every now and then, we are finding that he's a divorcee, she's a divorcee, and it is taken in a very common method, and it's being now considered a part of life. And people are not even reacting to all these things. Whether it's Delhi, whether it's Bombay, in film industry, we see so many cases of divorce happening after so many years of marriage. They are taking divorce. And so it's very common. But when I talk, this act is applicable throughout India. And when I talk India, I mean to say places outside, places which are not metropolitan cities, which are not cosmopolitan, which are not that advanced. You can talk about the villages, you can talk about the rustic people, you can talk about those people. So during that, as far as their society is concerned, it is still considered a blotch, it is still considered a stigma. So people do not want to have this stigma attached to them. As a result of which, when I say that judicial separation is a lesser evil, so and here you are not getting that stigma of that you are a divorcee. You are living separate, but you can live together also, but under one roof also, although you are not living like husband and wife. So that stigma is not that much attached to judicial separation. But when we see the reality, that I am talking about India as a society as a whole. When we see the reality, when people are, because we do feel that although now divorce is happening everywhere, Of course, it is more towards the urban societies as compared to the rustic society, the village people. But still, due to this common thing, people are still not taking it in a good manner, and to avoid this stigma, they are going for this judicial separation. But there's one very interesting thing that has been stated by Derrett. He states that although this judicial separation is available, when you talk about the urban societies, when you talk about the metropolis, here people are, though the grounds are identical, though they are exactly similar, people are not heading towards judicial separation. Although they can go for that thing, they are strictly going towards, they are directly going towards divorce, because that's it. As I have stated that divorce, in order to take divorce, it's not that you have to take judicial separation. You can directly apply for divorce. And as far as the courts are concerned, it might happen that if you have applied for judicial separation, although people are not going for that judicial separation, they are heading towards divorce directly only, and it's not a requirement also, so they are just going directly towards that thing. We do say that it's a stepping stone towards divorce, because if in a way that judicial separation has been given to you and 1 year period is given to you and you are not reconciling, then you become entitled for divorce. But when you go to the court, the view of the Derrett was that if you move to the court, even for judicial separation, you have taken a very hard stance. Going to the court is not that, it's not a cakewalk. People normally do not go to the courts. So when you have taken the recourse of court, that means something is really grave and weighty, and you really want that things should be separated once for all. And that is the reason a judicial separation is not being looked into in a very, they are not going more towards judicial separation. They are heading towards divorce directly only. But as far as the court is concerned, it might happen that if you have applied for divorce, they can give you judicial separation. But if you have applied for judicial separation, they will never give you divorce. Because it is always, the court always think that reconciliation is the best thing, and it is very good if the parties reconcile, because children are always in the mind of the court. I had stated in the beginning only, the worst, the bad impacted thing is the children of these couple. So if the couple is heading towards divorce, the children are the most affected parties. So if you have applied for divorce and the court feels that it is not such a ground that divorce could be granted, they can give you a lesser evil thing, that is judicial separation. But if you have applied for judicial separation, they will never give divorce to you. So that's a thing. These are the legal effects. I have already discussed this thing. Then filing petition for judicial separation, you need to specify the ground, you need to move an application, you need to file a petition, you have to comply with the formalities and the procedures that are there, and the judicial separation. So this thing is being given to the party. Then there have been so many cases. I have already stated that in one of the cases, the parties were living together for a number of years, and it was an aged couple, and the child of them was around 20 years, and after so many years of marriage, the couple had applied for a divorce. But in the present case, the court has stated that the grounds, there might be temperamental differences. Everybody has his or her own temperament. But after so many years, the child is 20 years of age, you are heading towards this thing. So the court in this particular case granted judicial separation and did not grant divorce to the party. Rita versus Brij Kishore is another thing where the court has given judicial separation. Here, the husband was a drunkard, he used to drink, and in spite of resistance from the wife had complained so many times, and he used to drink. But in one of the letters, he had also stated that he would reform, he would try to reform. So that means that reformation thing was there. So in this case also, the court had given judicial separation. And there are certain other number of cases. Ashay Manjan is another thing here. Although the wife, she had made vague allegations against her husband, and she had stated that her husband is having illicit connection with his elder married sister. But the court had laid down that there are so many fake cases, and it's a case of the women's allegations are not true, and the court had given judicial separation instead of divorce. So these are certain cases where it has given this thing. Now, when we talk about divorce, divorce is another, that was regarding judicial separation. In the case of divorce, I have already stated that divorce puts marriage to an end. After divorce, ties between the parties totally comes to an end. Now, after divorce, you are free to go your own way. You are free to go for another marriage. Your ties have been totally, it has come to an end, and now there is no tie between your ex, and because now you are a divorcee person. You are as good as a single person. Now, in the case of earlier, it was considered to be, when we talked about Manu, I had in my previous lectures talked about Manu Smriti, and we talked about the loyal position of how women was loyal, and the marriage was unbreakable. But with the due course of time, dissolution of marriage was allowed, and under Marriage Laws Amendment Act 1976, we had earlier judicial separation, and that divorce came into picture. There are grounds which are available. I have already stated 8 grounds are there which are available to both the husband and the wife. Earlier there were 9 grounds, but one ground, leprosy, has been done away with now. It's no more a ground, and we have 8 grounds available to both husband and wife, and 4 additional grounds are available only to the wife and not to the husband. Then there are 3 theories. If we talk about the divorce, there are 3 theories of divorce. The first is the guilt or the fault theory. Second is the consent theory. And the third one is the irretrievable theory of divorce. Now, when we talk about the first, I'll be taking it one by one. When I talk about the guilt or the fault theory, according to this theory, if one of the parties has, after the marriage has been solemnized, it has taken place, goes for any matrimonial offense, the other aggrieved spouse has got a right to move to the court and apply for divorce. So that means in the case of this guilt or fault theory, one of the parties should be a guilty party and the other one should be an innocent party. If both the parties are guilty party, then no one can move to the court, because when you have to move to the court, you have to go to the court with clean hands. It always says that a person cannot take advantage of his or her own wrong. So it says that in this guilt or fault theory, one party is a guilty party and another one is an innocent party. Earlier, we just had cruelty, desertion and adultery as the grounds of judicial separation. But later on, insanity was also added, and then it was realized and felt that when a person is insane, you can't say an insane person a guilty person. He has a fault in him, and that led to its renaming, and the name was given guilt or fault theory. So it stated that if any of the parties have any fault in them, then the other aggrieved party can move to the court and apply for for divorce. Now, earlier we had, as far as I have already stated, the grounds could be cruelty, adultery, desertion. Earlier we had leprosy, but now we do not have it. We have unsoundness of mind is there, venereal diseases there. Then venereal diseases are sexual transmitted diseases. Then we have presumption of death, renunciation of the world is there, conversion is there. These are the grounds which are available to both the parties. Apart from this, earlier there were 2 grounds, but then again 2 grounds were added. So presently we have 4 additional grounds which is available only to the wife and not to the husband. It could be pre-act polygamous marriage. It could be when the husband is guilty of rape, sodomy or bestiality. It could be when you have got a maintenance decree in your favor and there is non-resumption of cohabitation for a period of 1 year. Then the wife becomes entitled to move to the court and apply for divorce. It could be divorce or judicial separation. It could be when the marriage was solemn, a repudiation of your marriage. When the wife was before 15 years, she is married before 15 years, she dissolves it before 18 years, and whether the marriage is consummated or not consummated, that is immaterial under Hindu law. So these are 4 additional grounds which are available only to the wife and not to the husband. So this is all we would deal under guilt or fault theory. The next theory is the consent theory. Divorce by mutual consent is the one which is coming under this consent theory. It is always felt that these days we get married due to our choices, right? We do not, earlier it was like that, we used to take parents' permission, but now it is that we get married due to our choices. So we are free to go our way and get married the way we like. Just as we are free to get married, in a similar way, we should also be free to get divorce. In the sense that why to linger on the marriage which is not working? It's not that maybe the parties are not compatible. Earlier they had gone for marriage, but when they had started living together, they are not compatible with each other. And even when for the small things, they keep on fighting like cats and dogs. They feel like they become at daggers drawn. So there is no point in carrying that marriage forward. So the way you have entered your marriage freely, in a similar manner, you should also be free to come out of that marriage, and that is where this consent theory of divorce takes place. Divorce by mutual consent under section 13B is a clear-cut example of the consent theory of divorce. But there is one thing which has to be noticed under this consent theory is that just as the way it makes divorce very easy as well as very difficult. Easy in the sense that divorce by mutual consent, we usually consider that within a period of, that's the easiest way to take divorce from your spouse. Within a span of 1.5 years, you can move out of that relationship, which is not the case in the guilt or fault theory. It takes around number of years, endless number of years, 15 years, 14 years, and so on, where to take divorce. But in the case of this theory, it's the easiest way to take divorce, and within a span period of 1.5 years, you are out of that wedlock. So that it's very easy. But it becomes difficult in the sense, it has both the sides, in the sense that if one of the spouses do not want, or in order to trouble the other spouse, because when you are asking for divorce, obviously things are not right between the couple, this person will never give you divorce. So in order to trouble you, in order to make your life worse, in order to take, someone can be spiteful, someone can be revengeful. So that person might not go for this thing, and as a result of which, divorce will never take place in this kind of, as far as this theory is concerned. So it makes divorce very easy also and very difficult also. Apart from this, the third theory is, there's another theory of irretrievable breakdown theory. Irretrievable breakdown theory is the one. It says that when the marriage has broken beyond all repair, although it is not considered to be a ground of divorce in India, till date we do not have irretrievable breakdown theory of divorce. But although we will not deny to this fact that the Supreme Court under Article 142 in catena of cases, in incessant number of cases, they have given their decision based on this theory. Because, and it makes sense also, when the marriage between the parties is beyond repair, there are no chances of reconciliation. You are just lingering on that marriage for nothing. You are living separately for incessant number of years, 10 years, 15 years. So there is no point in retaining that empty shell. The marriage has broken. So why to retain that marriage? So in a number of cases, so it should come to an end. There are so many cases where Supreme Court has come into picture, and under Article 142, although it's not a explicit ground for divorce, we are not in India, it is not there. But under Article 142 of the Constitution, the Supreme Court has come into picture and had given relief to the spouses through this irretrievable theory. Endless number of cases. It could be Vinita Saksena's case, it could be Durga Prasanna Tripathi case, it could be Praveen Mehta's case, and so there are a number of cases. Naveen Kohli, Neelu Kohli's case. So there are a number of cases where the court had intervened and they had given this, they have given relief to the spouses on account of this theory. In my earlier lectures, I was talking about Saroj Rani's case, and I was talking about Saroj Rani versus Sudarshan Gorke, where the Supreme Court, the parties were just lingering on. The women had applied for restitution of conjugal rights, and then the husband, because he didn't want to go to the women, so he didn't, for that period of 1 year, he did not go to that woman, and as a result of which he became entitled for divorce, and then he applied for divorce in the court, and he was given by the High could. Then again that women went in appeal to the Supreme Court, and there the court had stated, it was a clear-cut case, that the marriage has broken. There is no point in retaining that empty shell. So if it is broken, you need to give away, you need to give up with such a relationship. So this turbulent relationship, when you are living for number of years at so many, I mean, if you see these cases, I had mentioned those cases, and if you see those cases, the parties had been living separately for a number of years. They were not living together. They were just, carrying on their marriage, and the husband was living at his parents' place, the wife was living at her parents' place. There were number of allegations and counter allegations that were carried on between the parties, and that there's no point. You are just troubling each other, and it's not that you are just, of course you are taking revenge, that's a separate story, but you are also not at peace. Your peace is also disturbed, because when you are going through the court, you are going through the cases, the allegations, it could be true, it could be fake. Number of cases, there are so many cases which are fake. You are just making allegations, charging allegations. You're just hurling abuses. So that there's no point to carry, because this no marriage is no marriage. It's just for the name's sake, you are a married couple. Otherwise, it's no marriage at all. And it does make sense to separate such spouses who have now gone so far off from each other, and they are totally incorrigible. They cannot be corrected. They cannot be made to come together and live together as husband and wife. So that's the thing. So that there is no point in carrying this marriage forward. So the Supreme Court had intervened as a result to do complete justice. Article 142 is there. In these cases, Supreme Court had intervened, and these are not the only cases. There have been number of cases where the court has intervened and had provided relief to the spouses. They were just troubling each other. They were just taking revenge. They were so spiteful. They were just countering allegations, countering allegations, so many fake cases. So the court had intervened and had brought relief to such spouses. So that's basically the third theory of divorce. So these theories of divorce are, applicable when we talk about, when I take section 13 and section 10 I had discussed today as judicial separation. 13 we will be talking, in my next lecture I would be talking about divorce. So when I take this, these are the things which are coming under your fault or guilt theory of divorce. I'll be talking about section 13b, that talks about divorce by mutual consent. That would come under your this consent theory of divorce. Irretrievable, we have till date not brought this, it's not there in India, but as I have already stated that under Article 142, the Supreme Court had provided relief to endless number of couples who were just troubling each other without any result. They also knew that there is no result out of such kind of turbulent relationship. So the Supreme Court intervened and they had provided relief to those couples. In my next lecture, I would be discussing about, because we had discussed about judicial separation today, and divorce is also connected in the sense because the grounds are same of judicial separation and divorce. So those grounds I will be dealing with divorce in my lecture, and grounds are identical as far as judicial separation and divorce are concerned, which will be starting in our next lecture. That would be on divorce under the Hindu Marriage Act. So with this, I bring to an end my lecture today, and judicial separation and divorce are really very, very important. Though people are going for divorce, they are heading for divorce, but this remedy, we do consider it, judicial separation, as a lesser evil as compared to divorce, which is a greater evil. But when you move to the court, obviously you are not in a situation to reconcile. So you don't want to reconcile. The main purpose of judicial separation was reconciliation, but people do not want that. You are moving to the court, that means things have gone beyond repair. Now you want to take action, and the easiest way they go for, simply they go for divorce and take divorce from the, although it's not that easy. When you go under fault or guilt theory, it takes number of years. Divorce by mutual consent is considered to be the easiest way. Within a span of these much years, you get rid of your turbulent spouse, your turbulent marriage. So that's the easiest way. So with this, I bring to an end this lecture. Thank you so much for listening to me and having patience. Thank you so much.
I am A.K. Sharma and I teach sociology at IIT Kanpur. I am going to address the question, what is the relevance of statistics in sociology? In India, there is some confusion about role of statistics in sociology, and most of the students of sociology suffer from what I call phobia of statistics. But actually, if you look at history of sociology or the kind of works that are being done in sociology, which are published in prestigious academic journals, you find that there is a lot of use of statistical methods, and not simple methods, very advanced methods. All of you know, as students of sociology, you know that one of the founding fathers of sociology, Comte, or another founding father, Emile Durkheim, they said that sociology is one subject which differs from other subjects in the questions that they try to answer, but they use the same method, the method of science. And that in sociology, those who believe in this kind of approach, they are called positivists. Emile Durkheim called them positivists. They believe that social issues must be studied by using observations, experiments, and other modes of collection of data. Now, statistics can help sociologists in three ways. Because if sociology is about social facts or patterns, not individuals, patterns of thinking, patterns of feeling, patterns of acting, behaving, and they can be measured, they can be quantified, and that explanation of one social fact can be given only in terms of other facts. We need statistics, because statistics can measure these facts, statistics can describe these facts. So, one branch of statistics, we can call it descriptive statistics, can help us in summarizing data, in measuring facts, like you are all familiar with simple statistical things like mean, mode, median, or methods of dispersion, standard deviation, range, variance. These are descriptive measures. They can also be used to measure skewness or symmetry or asymmetry in the data. Other types of statistical methods, which are called inferential statistics, are used to test hypotheses. We know that any science, including sociology, if we follow that positivistic tradition, is about testing hypotheses using scientific methods. And for testing hypotheses, like for comparative purposes, comparing means of two samples, or comparing variances of two samples, or comparing correlation coefficients or regression coefficients, we need inferential statistics. And if you are familiar with some of them, t-test, z-test, chi-square test, f-test, these are the tests which come under inferential statistics. We use statistics for drawing inferences about two or more samples. And thirdly, statistics can also be used for posing new questions. I remember that a few months ago, I read an article in Population and Development Review in which the authors Cole and Gramajo, they tried to explain homicide rates and variations in homicide rates across countries in the entire world. And they found based on statistical analysis, logistic regression and all. They found that one factor which explains variations in homicide rates in the world is female education, not culture, not governance so much, not even male education, but female education. Now, if facts are showing this, so you have a new sociological question, why is it that rise in female education leads to higher homicide rates? And Cole and Gramajo then gave certain hypotheses. You may not agree with those hypotheses, you may conduct this study on your own or test these hypotheses given by Cole and Gramajo using statistical methods. But the point I am making that in addition to describing data, drawing inferences, statistical methods can also be used for raising new questions in sociology. And of course, you are all familiar that whenever the issue of prediction comes, predicting population of India, predicting urbanization, predicting per capita income of India 20 years from now, 50 years from now, there also statistical methods are of great help. And finally, statistical methods have been used in monitoring and evaluation of development policies run by various governments and NGOs. Thank you very much.